Hello, good evening, and welcome to Indian political system. This paper is one of the most important paper in all the papers that you are going to study from first semester to your sixth semester. In this paper, that is Indian political system, I will be discussing with you fundamental rights of the Indian Constitution, directive principles, fundamental duties, that is one portion, and then we will move on to parliamentary democracy, state-central relations, judicial review, judicial activism, which is the second topic that I'm going to discuss with you. And then from then on, we will be discussing about political parties and pressure groups and how it evolved in Indian political system. So, the first topic that we are going to discuss is fundamental rights of the Constitution of the Indian Constitution or of the Constitution of India. My dear students, I want you to take this paper seriously. I mean it seriously. Because when you sit for any competitive exam, be it Union Public exams conducted by Union Public Service Commission, be it the civil service exam, or if you want to sit for any paramilitary force, for example CAPF or CDS, or let's say state service exam, they are going to pick up from this very paper, Indian political system. And fundamental rights of the Indian Constitution or of the Indian political system constitutes one of the core area of Indian political system, and core area where the examiners or all the commissioners, Union Public Service Commission or State Commission, they ask from this portion a lot, because fundamental rights or Supreme Court or judicial activism, parliamentary democracy, all this happens every now and then. It is there in the news every now and then. So they cannot do away any exam without asking questions from all this. So do not just focus on clearing or passing this third semester, but focus on what do I do with the things, with the topics that I have learned. So we'll start with fundamental rights of the Indian Constitution. A brief background about it. Fundamental rights of the Indian Constitution. How this comes about. You might have studied in your class 11 and 12 or even 10, 8, 9, 10 standard. This is not a new topic. You are familiar with it. So you know that Part 3 of the Indian Constitution from Article 12 to 35 talks about fundamental rights, which is often also described as Magna Carta of the Indian Constitution, Magna Carta of India. And you know that we borrowed this from the Constitution of United States of America. But what you may not know is, when does this fundamental right first appear in the Indian national movement? We do not just borrow from United States Constitution, but there are certain incidents. Now they may ask, when was the first time that fundamental rights appeared in the Constitution? I mean in Indian political system, in Indian national movement. It was during 1928 after the Simon Commission. Simon Commission came. It was all white commission, and so there was a protest. When you discuss about modern Indian history, you will be discussing about this. 1927 Simon Commission came. It was all white commission. There were no Indians. Simon as the leader of it, and the Indians were protesting, "Go back, Simon." That was the slogan that they used. So with this, they cannot agree with the Simon Commission, and with this, Motilal Nehru, the father of Jawaharlal Nehru, on February 1928 passed the Nehru Report. This was the first time fundamental rights, 19 fundamental rights, appeared in the Indian national movement, demanding certain fundamental rights for the people. That was the first time that it appears in Nehru Report. And then, which was further reiterated, further endorsed in Karachi session of 1931, Vallabhbhai Patel, the Statue of Unity. Vallabhbhai Patel, when he was the president in Karachi session 1931, two resolutions were passed. And one such resolution was fundamental rights, freedom of speech, expression, belief, faith, and worship. The other resolution, that's your homework to find out. So, for the fundamental rights, these fundamental rights are guaranteed by the Constitution. These are guaranteed, given by the Constitution, and guaranteed that this will be protected by the Constitution. Guaranteed by the Constitution. To all persons, it doesn't matter where you come from, where you reign from, where is your origin, it doesn't matter. Without any discrimination, this fundamental right is granted to all people, all individual. And they uphold the equality of all individual, the dignity of all the individuals, of course, at the larger public interest and at the unity of the nation. Unity of the nation and the larger public interest, of course, come first, and then fundamental rights. So fundamental rights are meant for what? What is fundamental rights meant for? Do we have, does countries like, communist countries like China has fundamental rights? Of course they may have, but not like ours. So fundamental rights are meant for promoting the ideals of political democracy. They prevent the establishment of authoritarian or dictatorial or despotic states, monarchical state. It is there, fundamental rights is guaranteed in the Constitution so as to protect the liberties and freedom of the people against the invasion of the state. So that the rights and liberties, the interest of individuals are protected. So that there are limitations on the tyranny of the executive and arbitrary laws passed by the government, passed by the legislature. In short, fundamental rights exist so that there is government of law and not government of man. In other words, we follow a rule of law system that we discuss when we discuss about British political system. We discuss about rule of law. It is the law that governs, not man or not particular individual. They function under the Constitution. Prime Minister exercises its power under the Constitution. The government, the Council of Ministers, acts according to the power and functions given by the Constitution. So these fundamental rights exist so that the rights of individuals are protected and the government does not become arbitrary and political democracy is protected at all cost. That is brief introduction about fundamental rights. Let us move on to the next point. Fundamental rights. Just give me a minute. I'll come back. So, fundamental rights, Part 1, Article 12 to 35, talks about fundamental rights of the Indian Constitution. Even if you don't remember the constitutions, the articles of the Constitution, please try to remember the articles of fundamental rights because it will be very helpful when you sit for any competitive exam. There are 6 fundamental rights. Originally, there are 7 fundamental rights. The right to property, but let me first discuss about this 6 fundamental rights. Right to equality, Article 14 to 18. Right to freedom, Article 19 to 22. Right against exploitation, Article 23 and 24. Right to freedom of religion, Article 25 to 28. Cultural and educational rights, Article 20 to 30. And right to constitutional remedies, Article 32 to 35. Originally there were 7 fundamental rights. That is, right to property, which comes under Article 31. However, this right to property was deleted from the list of fundamental rights by the 44th Amendment Act 1978, and this was made a legal right under Article 300A of Part 12 of the Constitution. So at present, we have just these 6 fundamental rights. We will be discussing about all these rights in detail, but before we move on to that, let us first see the features of fundamental rights. What are the features of fundamental rights? Okay, the first feature. Some are available only to citizens, while others are available to all persons, whether citizens or foreigners or legal persons or like corporates and companies. Now see, some are available only to citizens while others are available also to foreigners. What are those rights which are available only to citizens? You have studied this in your 11 and 12 in your 10th standard. So what are those fundamental rights available only to citizens and not to foreigners? If you can recall, Article 15, prohibition of discrimination on ground of religion, race, caste, sex, place of birth. These are available only to citizens. There can be discrimination based on birth. There may be some privileges available. As a citizen of India, you have these rights which a person from United States of India residing in, United States of America is residing in India may not enjoy. So there is discrimination, but this is applicable only for foreign citizens. Prohibition of discrimination on ground of religion, race, caste, sex, or place of birth. Article 15. These are available only to citizens. There cannot be any prohibition for citizens, but there can be prohibition of discriminations for foreigners. Another example is Article 16, where Article 16 talks about equality of opportunity on matters of public employment. So there must be equality of opportunity on matter of public employment without any discrimination for all citizens of India, but not all people of the world. This is not available for other states like citizens of Pakistan or like citizens of United States of America. But what are those fundamental rights which are available to both citizens and foreigners? You take off Article 21, which talks about right to life and personal liberty. Every person, every individual enjoys the right to life and personal liberty, which is available not only to Indian citizens, but also to citizens of United States of America, any citizen, any human being. The next is other example of fundamental rights which are available also to foreigners as well as citizens is, you talk of Article 14. Article 14 talks about equality before law and equal protection of law. Everyone, every person, individual, black or white, Latino or Americans, Asians or Africans, it matters not. All citizens, all people of this world, all human beings enjoy equal protection of law and equality enjoys equality before law and equal protection of law. That is the first feature. The next feature is fundamental rights, my dear students. They are not absolute, but they are qualified. What does this mean? Which means that the state can impose reasonable restriction on them. The state can impose reasonable restriction on them. For example, right to freedom of speech, or Article 19. Some of it might be taken away during national emergency. Some of the rights, fundamental rights, may not be enforceable during national emergency. And that is why it is not absolute but qualified. However, mind you, whether such restrictions are reasonable or not, that must be decided by the court, by the Supreme Court or High Court, so as to strike a balance between rights of individuals on the other hand and rights of society as a whole on the other. So as to keep a balance, a control between individual rights and social control. These are not absolute, but qualified. The next point, they are justiciable. What does this mean? This is one of the difference between fundamental rights and directive principles and fundamental duties. Directive principles and fundamental duties are not justiciable, whereas fundamental rights are justiciable. They are justiciable, which means an individual can go to the court of law to claim its rights whenever the state tries to take it away. They are justiciable, means allowing person to move to the court of law for enforcement if and when they are violated. When the state violates, let's say Article 25, freedom of conscience and free profession, practice and propagation of religion. When the state tries to interfere in my religious affair, then you can move to the court of law and enforce such and ask the court for enforcement of such laws which has been taken away by the state. The other is, I do not mention here, but which is worth mentioning, is there are two types of rights again in our fundamental rights. There is negative rights and positive rights. Some are, in other words, some are negative in character. That is, they place limitations on the authority of the state. And the others, while are positive in nature, that is, conferring certain privileges on the person. What are these negative? What are these rights which are negative in character? Let me cite an example of negative in character, like Article 15, because they place prohibition on discrimination on ground of religion, race, caste, sex, place of birth. The state shall not prohibit. The state shall not discriminate a person against. I'm sorry, I repeat it again. The state shall not discriminate on any ground of religion, race, caste, sex, or place of birth, which comes under Article 15, which is placing restriction on the authority of the state, which is negative in character. Another example is abolition of untouchability or prohibition of the practice of untouchability, which comes under Article 17. Try to remember all these articles because it will help you when you are sitting for any competitive exams, especially fundamental rights. What about positive in character? Positive characteristics of fundamental rights. There are certain fundamental rights which are positive in nature. In other words, conferring certain privileges on the persons. What are these rights? The perfect example is your Article 19. Article 19 talks about 6 fundamental rights. It talks about, 6 fundamental freedom. Freedom of speech and expression. Freedom of assembly. Freedom of association, movement, restriction, and profession comes under Article 19, which encourages an individual to be his best self, which is positive in character. That means it is providing an opportunity for a person, conferring certain privileges for the person to be his best self. Positive in character. The next point is they are not sacrosanct or permanent. What does this mean? This means that the parliament can curtail or repeal them, but only by a constitutional amendment act and not by ordinary act. We will discuss this when we discuss about Article 13. I'll explain this when we down the line will be discussing about Article 13. But briefly, what is this? These are not permanent. Fundamental rights, I'm so tempted to explain this. Fundamental rights are not permanent. Fundamental rights are not permanent. They are not sacrosanct. They can be changed. There was this famous case of Kesavananda Bharati case, 1973. Kesavananda Bharati case versus State of Kerala. Earlier, I think it was in Kolaknath case. I may be wrong. Kopala or Kolaknath case, 1950s or something there. Earlier, it was said that the constitution, the parliament cannot change even the fundamental rights. It was that. But in Kesavananda Bharati case, the Supreme Court states that the parliament can change fundamental rights, which is why Article 31, right to property, was removed. But the Supreme Court also stated under Kesavananda Bharati case that the basic structure of the constitution cannot be changed. The parliament can change anything. The parliament has the power to change the fundamental rights, provided they do not change the basic structure of the constitution. So these are not sacrosanct. Fundamental rights are not sacrosanct or permanent. They can be changed by the parliament through an act of amendment. So in an examination, they may ask, Fundamental rights cannot be changed by the constitution. Cannot be changed by the parliament. Directive principles cannot be changed by the parliament. Fundamental rights, fundamental duties can be changed or altered by the constitution. True or false? Which one is true? Which one is false? A or B? A only? B only? A or C? A, B, C? All of the above. So you have to understand this. So I'm telling again, they are not sacrosanct or permanent. Fundamental rights can be changed, can be removed. The perfect example is removal of Article 31, right to property by the right to property under during constitutional right to property under Article 31 during Constitutional Amendment Act of 44th Constitutional Amendment Act 1978. I guess I'm right. The next is they can be suspended during emergency. These fundamental rights, as we have discussed, are not sacrosanct or permanent. They can be suspended during emergency. During the operation of national emergency, except rights guaranteed under Article 20 and Article 21. What does this Article 20 and Article 21 talks about? Article 20 is basically about protection in respect of conviction for offenses. When a person is convicted for offenses, he should be provided the right to trial, the right to stand in the court of law, which has certain other features we will be discussing subsequently. The next is Article 22, which talks about protection against arrest and detention in certain cases. Oh, this is not, I'm sorry, actually this shouldn't be Article 22. It's not Article 22. Except Article 22 is prevention of detention, protection against, this is a very controversial article. This should be Article 21. I'm sorry for the mistake. This should be Article 21, I repeat, except Article 20 and Article 21. Article 21 talks about right to protection of life and personal liberty. Even during emergency, these rights, protection, even during national emergency, during national emergency, Article 20 or 21 cannot be suspended even during emergency. When we talk about Article 19, those 6 fundamental rights under Article 19 can be suspended only during emergency, on the ground of war or external aggression, and not on the ground of armed rebellion. See, when there is internal conflict or internal armed rebellion, this Article 19 can be suspended only when emergency is declared on the ground of war or external aggression. But if there is internal conflict or armed rebellion within the country, this Article 19 of the Indian Constitution, Article 19 of the Indian Constitution cannot be suspended. Cannot be suspended during internal or armed rebellion is a better word. Armed rebellion. It cannot be suspended during armed rebellion. Only only when there is external aggression or war, it can be suspended. But Article 20 or 21, at all cost, be it national emergency or whatever, it cannot be suspended. Article 20 and 21. This is not 22, 21. The next point is restricted while martial law. Now, this application can be restricted while martial law is in force in any country. And now you may ask, what is this martial law? What is this martial law? The perfect example is Armed Forces Special Power Act. Armed Force Martial law means military law imposed under abnormal circumstances in order to restore order in that particular region or particular state. When there is abnormal situation, when there is conflict or crisis in that particular region, military law, military rule is imposed so as to restore that order in that particular region or particular state. Okay, that is all in brief about the nature of or characteristics, brief features of Indian fundamental rights. What is this Article 13? Why I'm very specific about this Article 13. Article 13 declares that all laws that are inconsistent with or in derogation of fundamental rights shall be void. In other words, it is trying to say that it expressively provides for the doctrine of judicial review, which means that Supreme Court or the Court of Law, Supreme Court or High Court can intervene and see whether this is constitutionally valid or not. The laws passed by the Parliament are constitutionally valid or not. If it is not valid, then the Constitution can declare. Then the Supreme Court or High Court or the Court of Law can declare it as null and void. What are these laws? All laws. Okay. So all laws, yeah. Laws means now, what are these laws? Now you may ask, what are these laws? All laws, it's a very confusing term. So Article 13 also provides that there are certain laws which are qualified. These laws are permanent laws enacted by the Parliament from time to time, enacted by the Parliament or the state legislature from time to time, temporary laws like ordinances passed by the President of India, issued by the President or the State Governor. These laws also includes statutory instrument in the nature of delegated legislations like orders, rules, regulations, notifications passed by the concerned authority. Or these laws also includes, the term laws also includes non-legislative sorts of laws like customs or usages having the force of law. These are laws when Article 13 states law, all law that are inconsistent. All these laws that I have discussed about, permanent laws passed by the Parliament, it's not coming out, I'm sorry. Then temporary laws like ordinances, statutory like orders, regulations, customary laws, and usages having the force of law. All these are examples of law. But the Constitution also states that Constitutional Amendment Article 368 is not a law and therefore cannot be challenged. Article 13 further declares that constitutional amendment is not a law. Constitutional amendment which comes under Article 368 is not a law, and so it cannot be challenged. Which is why I was talking about Kesavananda Bharati case. Yeah, cannot be challenged. Constitutional amendment cannot be challenged. So when Article 31, right to property, was removed, it cannot be challenged. However, the Supreme Court held in Kesavananda Bharati case, where we discussed earlier, that the constitutional amendment can be challenged on the ground that it violates fundamental rights that form a part of basic structure of the Constitution, and hence the Constitution can be declared null and void. Are you with me? I'll explain it again. Article 13 Article 13 states that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void, which is not in accordance with fundamental rights, cannot be called a law, can be declared void, cannot be applicable to citizens. All laws should go in accordance with the fundamental rights of the citizens of India. However, the Constitution under Article 13 also declares that a constitutional amendment which comes under Article 368 is not a law. Since it is not a law, it cannot be challenged in the court of law. Only all these laws that I have said, parliamentary laws enacted by parliament or state legislature from time to time, temporary laws like ordinances issued by president or governor, or statutory instruments like order, regulations, notifications, and all these, or non-legislative sources of laws like customs or usages having the forces of laws. All these are examples of law, but not constitutional law, because constitutional laws are not. Not constitutional amendment, because constitutional amendment is not a law. However, the Supreme Court also held in the Kesavananda Parity case versus State of Kerala in 1973, it held that a constitutional amendment can be challenged on the ground that it violates a fundamental right that form the basic structure of the Constitution. If it only violates fundamental rights, then fine. If the amendment only takes away fundamental rights, then fine, so long as it does not affect the basic structure of the Indian Constitution. So Article 31, removal of Article 31, right to property, was fine because it does not affect the basic structure of the Indian Constitution. But when they come up and say, oh, let's remove Article 2930, or let's remove Article 21, right to protection of life and personal liberty, the Supreme Court can struck down such amendments because it violates the very basic structure of the Indian Constitution. When we talk about Article 25 or 26 or 27, or Article 25, let's say, freedom of conscience and free profession or practice of one's religion according to one's choice. That is, we have a basic structure of, we endorse secularism. Secularism is endorsed. So if the Constitution, if the parliamentarians try to take away our freedom of religion, then the Supreme Court can struck down such acts or such laws, such amendment, stating that this violates the basic structure of the Indian Constitution. That is all for today. In the next class, we will be discussing in detail about right to equality, right to freedom, cultural and educational rights, right to freedom of religion, and subsequently your constitutional remedies. Thank you so much for your kind, patient listening. See you again in the next class.